last year in September, we filed an adjustment of status, right? It's based on a 245I case. It's kind of complicated. We filed it. What we didn't expect was after the adjustment of status was filed, USCIS transfers the case over to immigration court before terminating it. So normally you deny the case and you give an NTA and you transfer. This happened simultaneously. So that's bizarre, number one. And then, number two, when USCIS administratively closed the case saying, sorry, you were paroled in and you got an NTA, notice of intent to appear, and therefore we cannot adjudicate your adjustment of status. We don't have the jurisdiction. We're transferring it over to immigration court. So that's bizarre number two, right? The client came in, was paroled in, got married to a U.S. citizen. We filed an adjustment of status. In years past, boom, approval, green card. Now USCIS is saying, sorry, it's not our call. It's not within our jurisdiction. ICE and Department of Homeland Security is taking over, and you have to go through immigration court. Okay, weird. We filed a motion. Please close this case. Immigration court, immigration judge, please terminate this proceeding. Why? Because our client was paroled in, got married to a U.S. citizen, and filed an adjustment of status. It qualifies under 245A. Please close it. And then we'll redo it with USCIS. Then the Department of Homeland Security says, nope. This is the Assistant Chief Counsel for U.S. Department of Homeland Security. And they filed a response to our motion. And this is what they said. The U.S. Department of Homeland Security opposes the respondent's renewed motion to terminate for the following reason. It is well established that parole is not considered an admission into the United States for adjustment purposes. And they go on and talk about it. Here, the respondent was not admitted or paroled after inspection by an immigration officer at the time of her entry into the United States. And while we granted the parole and released her into custody, the grant of parole terminated when she was served with a notice of intent to appear, and therefore she cannot adjust status. At this time, the respondent has not met her burden to prove that she is not inadmissible as charged and that she is prima facie eligible for 245A adjustment of status because she was not paroled, right? So basically, they were just saying, sorry, if you're paroled, you cannot adjust, and cited all these laws and case laws. I want to share with you how we fought that. Man, I loved this brief. The U.S. Department of Homeland Security opposition to respondent's motion to terminate should be denied because it is premised on a fundamental misreading of 245A. The respondent was released from the U.S. Customs Enforcement and was lawfully paroled into the United States. See all these exhibits. She subsequently became the immediate relative of a U.S. citizen through marriage and filed a properly supported application for adjustment of status. The Department of Homeland Security argues that the parole does not constitute an admission for adjustment purposes. However, respondent does not claim admission. We don't need admission. Under 245A, it expressly provides two independent bases for eligibility, being inspected or admitted, or inspected and paroled. Congress deliberately included parole as an alternative basis for adjustment eligibility. And so this squarely satisfies the requirement for 245A. The Department of Homeland Security further contends that the respondent parole was terminated, quote unquote, upon issuance of the NTA. However, on the same day the NTA was issued, the Department of Homeland Security also issued her a call-in letter directing respondent to appear in a future appointment to be issued a new parole. So the issuance of these additional documents of parole was not treated as extinguished. Rather, Department of Homeland Security affirmatively recognized respondent's parole status and anticipation and continuation of her parole status. And we even prepared a new 45 adjustment of status to submit to the court and said, you know what? Even if you're right, officer, even if you're right, immigration judge, that parole was canceled and USCIS has the right to transfer the case over to immigration court, we respectfully request that you just approve the green card here and now because the law is on our side. Now, we didn't have to go that far because the court just said, we agree with you, terminate this case, And now we're going to go back to USCIS to reopen the case. In this day and age, in this era, where USCIS is just kind of shifting their troubled cases over to immigration court, and immigration court is just detaining people, the one solution that you can do and you must do is to terminate the proceedings. Terminate the immigration proceedings, terminate the deportation proceedings, close it out, and then transfer it back to USCIS to get approved. Plan B is to force the immigration judge, based on the rights and privileges and responsibilities granted to them, to then adjudicate the case as if they're a USCIS officer and then approve the green card. So give us heaven, or at least send us back and we will fight it again. And don't let ICE, don't let them detain the client and refuse bond, because that's what they're doing. They're doing it to green card holders who are entering the country. They're like the 72-year-old grandma from last week. They're doing it to visa waiver people who are, marrying U.S. citizens. When the government makes an argument, double check their argument. Maybe they ChatGPT'd it and they hallucinated. Maybe it's not correct. Fight them every way. And there are still good immigration judges, such as this one, who approved the termination, the case is closed, and now the client still has a chance to get the green card back with USCIS. Extremely proud of the team that worked heavily on this case. Gabby, Giselle, and we won. And so these are still possible. And again, also I want to shout out Arthur, who was shadowing us the entire time, helping us work on this case. I want to shout out Emily. I want to shout out Megan. I want to shout out Nicholas. I want to shout out all the attorneys who kind of came together, who really helped and to strategize, because we had to win at all costs. Thank you guys. Take care. See you next week. Bye-bye.